Okay, good morning everyone. Welcome back to e-commerce. Today is October 23rd, 2019. We're going to be continuing on today with Chapter 7, the ethical, social, and political issues in e-commerce. I'll be starting on page 271 of the text if you want to follow along with me. It is the Internet and Government Invasions of Privacy, E-commerce Surveillance. So today, the online and mobile behavior profiles and transactions of consumers are available to government agencies and law enforcement authorities. And now in 2012, there was a surge in the use of cell phone tracking and surveillance of citizen movements by law enforcement authorities. So law enforcement authorities have long claimed the right under numerous statutes to monitor any form of electronic communication. Now, this is going to be pursuant to a court order and a judicial review, and based on the reasonable belief that the crime is being committed. So, if we have the court order, judicial review, and reasonable belief that a crime is being committed, then the law enforcement authorities have the right to monitor the forms of electronic communications. Now, this is going to include the surveillance of consumers engaged in e-commerce. So any activity that goes on these e-commerce sites is also going to be available to authorities. Now, the Communications Assistance for Law Enforcement Act, the USA Patriot Act, the Cybersecurity Enhancement Act, and the Homeland Security Act are all going to strengthen the ability of law enforcement agencies to monitor internet users without their knowledge. And under some circumstances, when a life is questionably at stake, without any judicial oversight. So what's that mean? It means that if they think that someone's life is at harm or could be in jeopardy, then they don't even need a judicial review. They can just tap right into it and just get right to business. Now, the Patriot Act, designed to combat terrorism inside the U.S. borders, permits nearly unlimited government surveillance without court oversight. And this was relayed to us by a number of U.S. senators. Now, government agencies are among the largest users of private sector commercial data brokers, such as ChoicePoint, Axiom, Experian, and TransUnion Corporation. Now, these all collect a vast amount of information about consumers from various offline and online public sources. Axiom is the largest private personal database in the world, with around 500,000 people that are actually in this database, and about 1,500 data points per person out of these 500,000 people. So, quite astounding if you think about it in terms of the amount of information they have on individuals. Now, the European Union has indicated that it should not be retained for more than 6 months, retention, got ahead of myself. Retention of search engine query data is also an issue when it comes to the invasions of privacy. The European Union has indicated that it should not be retained for more than 6 months. So we're talking about the data here that is stored in these search queries. That the EU says that it should not be retained for a period of longer than 6 months. Now, the three major search engines have varying policies. We know the major search engines are going to be Google, Bing, and Yahoo. Once again, they all have varying policies on how they retain this data. In January 2010, Microsoft agreed to reduce the amount of time that it retains certain data. This data being in the form of IP addresses, most certainly. So, and they actually agreed to reduce the amount of time to 6 months to comply with the EU standards. So they had been retaining this data for longer periods of time, and they agreed to comply with what the EU standard is of 6 months. Google has refused and retained search records for 18 months. And their claim is that this amount of time is necessary to improve services and prevent fraud. Now, in April 2011, Yahoo, which had previously prided itself in retaining search records for only 3 months, said that they were going to amend their policy and follow suit with Google and extend that time to 18 months. And their reasoning being was that it was for a competitive advantage or for competitive reasons. So you be the judge. How long do they really need to hold on to this data, and what are they doing with this data? I highly doubt it's for competitive reasons. So I'm sure some of it is, but for the most part, I think it's more for just tracking you and knowing your behavior and ultimately trying to obviously fulfill their marketing desires and their goals, but at the same time, as we know, it's impeding upon our privacy. Now, what are some of the legal protections that are available to us as individuals and consumers? Now, in the United States, Canada, and Germany, rights to privacy are granted or can be derived from founding documents such as constitutions, as well as in specific statutes. Now, in England and the United States, there's also protection of privacy in common law. So a body of court decisions involving torts or personal injuries. Now, in the United States, there are 4 privacy-related torts that have been defined in the court decisions that involve claims of injury to individuals caused by other private parties. Now, these 4 privacy-related torts are going to be known as intrusion on solitude, public disclosure of private facts, publicity placing a person in a false light, and appropriation of a person's name or likeness for a commercial purpose. Now, in addition to common law and the Constitution, there are both federal laws and state laws that protect individuals against government intrusion. Table 7.4 on page 273 is a list of some federal privacy laws. On the left, it gives you the name of what the law is, and on the right, it gives a description. I'm not going to get into these laws in detail right now in class, but please do take some time to read over this, as this could be a good chart that I could use to pull questions for the final exam in this class. So informed consent is going to be our next topic. The concept of informed consent is going to be defined as consent given with knowledge of all material facts needed to make a rational decision. So that's what informed consent is. Now, obviously, the concept of informed consent is going to play an important role in protecting our privacy. In the United States, business firms and government agencies can gather transaction information that is generated in the marketplace, and then they use that information for other marketing purposes without obtaining the informed consent of the individual. Now, in Europe, this would be illegal. A business in Europe cannot use marketplace transaction information for any purpose other than supporting the current transaction, unless, of course, it obtains the individual's consent in writing or by filling out an on-screen form for them to be permitted to do so. So in Europe, this would be illegal. Now, there are traditionally 2 models for informed consent. We have the opt-in and the opt-out model. Now, the opt-in model is going to require an affirmative action by the consumer to allow collection and use of information. So a good example of an opt-in model would be consumers would first be asked if they are approved of the collection and use of information, and then directed to check a selection box if they agreed. Otherwise, the default is not to approve the collection of data. So they have to get you to opt in prior to them collecting this data and using it for their own purposes. Now, on the other side, we have the opt-out model. And in this case, the default is to collect information unless the consumer takes an affirmative action to prevent the collection of data. And this can be done by checking a box or filling out a form. The Federal Trade Commission's Fair Information Practices Principle. Now, in the United States, the Federal Trade Commission, known as the FTC, has taken the lead in conducting research on online privacy and recommending legislation to Congress. The FTC is a cabinet-level agency that's charged with promoting the efficient functioning of marketplace by protecting consumers from unfair or deceptive practices and increasing consumer choice by promoting competition. The FTC also enforces existing legislation by suing corporations that it believes are in violation of federal fair trade laws. So the FTC plays an important role here. In 1998, the FTC issued its Fair Information Practice, known as the FIP. Now, its principles have been based on its assessments and recommendations for online privacy. Table 7.5 describes these principles. I'm not going to go into what the meat of these principles are per se, but I will just mention what they are. So Table 7.5 on the bottom of page 274, Federal Trade Commission's Fair Information Practice Principles. There are 5 principles here. They are notice and awareness, which is their core principle. Choice and consent, which is another core principle. Access and participation. Security and enforcement. So these are going to be your five fair information practice principles that are put in place by the FTC. Once again, take time on your own to read through these. I'm not going to just stand here and bore you and read them verbatim. You need to do this on your own time. Once again, it's page 274 at the bottom, table 7.5. Some of the Federal Trade Commission's Fair Information Practice Principles. So the FTC's FIP principles are going to set the ground rules for what constitutes due process, privacy protection procedures at e-commerce and all other websites. And this is going to be for in the United States that the FTC does this. Now in 2000, the FTC recommended legislation to Congress to protect online consumer privacy from the threat posed by advertising networks. In the last decade, the FTC's privacy approach has shifted somewhat. They've moved away from notice and choice requirements and into a harm-based approach that are targeting practices that are likely to cause harm or unwarranted intrusion in consumers' daily lives. In 2009, the FTC held a series of 3 public roundtables to explore the effectiveness of these approaches. And the major concepts that emerged from these roundtables were the increasing collection and use of consumer data, consumers' lack of understanding about the collection and use of their personal data, and the resulting inability to make informed choices, consumers' interest in and concern about their privacy, benefits of data collection and use to both businesses and consumers, decreasing relevance of the distinction between PII and non-PII. And now as a result of the roundtables, the FTC has developed a new framework to address consumer privacy. Now Table 7.6 summarizes the important aspects of this framework. Table 7.6 is located at the bottom of page 275, and it is known as the FTC's new privacy framework. On the left-hand side, we have the principle. On the right-hand side, we have the application. Just as I did for Table 7.4, I'm not gonna go into the meat of this table. I'm only going to list what the actual principles are. You need to do this on your own time. Go through and read through these principles and what the relative application that applies to each of these principles are. So these principles on the left-hand side, if we can see here, are scope, privacy by design, simplified choice, and greater transparency. So once again, this table, the FTC's new privacy framework is on bottom of page 275, table 7.6. Please take some time to review over this on your free time. Now, in response to growing public and congressional concern with online and mobile privacy violations, in 2011 and 2012, the FTC began taking a much more aggressive stance based on these new privacy policies. In March 2011, the FTC reached an agreement with Google concerning charges it used deceptive tactics and violated its own privacy policies when it launched Google Buzz, which is a social network. What the issue was is they were forcing people to join the network even if they selected not to join. So there was really no choice. Now, under the settlement, Google agreed to start a privacy program, permit independent privacy audits for 20 years, and face $16,000 fines for every future privacy misrepresentation. Then once again in August 2012, the FTC fined Google $22.5 million to settle charges that it had bypassed privacy settings in Apple's Safari browser. And what they did in this Apple Safari, the browser, is they were able to track users of the browser and show them advertisements. And this violated the earlier privacy settlement with the agency. So hence the $22.5 million settlement that was reached in 2012. Now, in August 2012, the FTC also reached a settlement with Facebook, resolving charges that Facebook deceived its users by telling them they could keep their information on Facebook private. But in all reality, they repeatedly allowed it to be shared and made public without the individual's consent. So they were telling them one thing and then doing another. Not a good look. Now, the settlement requires Facebook to live up to its promises by giving consumers clear and prominent notice of obtaining their express consent before sharing their information beyond the user's privacy settings. It also requires Facebook to develop a comprehensive privacy program and obtain independent privacy audits for a period of 20 years. Now, in March 2012, the FTC released a final report based on its works in the previous 2 years. The report describes industry best practices for protecting the privacy of Americans, and it focuses on 5 areas. Do not track, mobile privacy, data brokers, large platform providers, and the development of self-regulatory codes. Let's move on to the European Data Protecting Directive. In Europe, privacy protection is much stronger than it is in the United States. In the United States, there is no federal agency charged with enforcing privacy laws. Instead, privacy laws are going to be enforced largely through self-regulation by businesses and by individuals who must sue agencies or companies in court to recover damages. Unfortunately, this is rarely done because of the expense. Anyone who's ever been through litigation knows it's a long, boring, and tough process, and a lot of times the result cannot be good. It's just the way our court system's set up, unfortunately. The European approach to privacy protection is more comprehensive and regulatory in nature. They enforce their privacy laws by creating data protection agencies to pursue complaints brought by citizens and actively enforce privacy laws. So on October 25th, 1998, the European Commission's Data Protection Directive went into effect. What it did was standardize and broaden privacy protection in the EU nations. The directive requires companies to inform people when they collect information about them and to disclose how it will be stored and used. Customers must provide their informed consent before any company can legally use data about them. They also have the right to access that information, make corrections to it, and request that no further data be collected. Another important feature of this law is it prohibits the transfer of the PII to organizations or countries that do not have similar strong privacy protection policies. So what does this mean? It means that data collected in Europe by American business firms cannot be transferred or processed in the United States due to the fact that we have weaker privacy protection laws. So the U.S. Department of Commerce, working with the European Commission, developed a safe harbor framework for U.S. firms. Now, a safe harbor is a private self-regulating policy and enforcement mechanism that meets the objectives of government regulators and legislation, but it does not involve government regulation or enforcement. Private industry self-regulation. The online industry in the United States has historically opposed online privacy legislation. They argue that the industry can do a better job of protecting privacy than that of the government. The online industry formed the Online Privacy Alliance, known as the OPA, in 1998, and it was made to encourage self-regulation in part as a reaction to growing public concerns and the threat of legislation being proposed by the FTC and privacy advocacy groups. Now, the FTC and private industry in the United States has created the idea of safe harbors from government regulation. Now, in general, industry efforts at self-regulation and online privacy have not succeeded in reducing American fears of privacy invasion that would occur during online transactions, or in reducing the level of privacy invasion. At best, self-regulation has offered consumers notice about whether a privacy policy exists, but usually says little about the actual use of the information. So what are some of the technological solutions? So there's a number of privacy-enhancing technologies that have been developed for protecting user privacy during interactions with websites, such as spyware blockers, pop-up blockers, cookie managers, and secure email. Now, the most powerful tools for protecting privacy are going to need to be built into the browsers itself. Now, one of the most powerful browser-based protections is built-in Do Not Track capability. Now, Microsoft, Mozilla, Google, and Apple have all committed to introducing a default Do Not Track capability by 2013. And most of these tools emphasize security, which is the ability of individuals to protect their communications and files from illegitimate snoopers. Next, the next section that we're going to move on to is 7.3, Intellectual Property Rights. This is on the bottom of page 278 for those following along. So next to privacy, the most controversial, ethical, social, and political issues relate to e-commerce is the fate of intellectual property rights. Now, intellectual property encompasses all the tangible and intangible products of the human mind. And as a general rule in the United States, the creator of the intellectual property owns it. A good example is if you create an e-commerce site, that it belongs to you, it's yours. Now, once intellectual works become digital, it becomes more difficult to control access, use, distribution, and copying of the actual intellectual works. Now, these are the exact areas that the intellectual property seeks to control, is this digital environment. Now, digital media differ from books, periodicals, and other media in terms of ease of replication, transmission, and alteration. Now, the internet technically permits millions of people to make perfect digital copies of various works, from forms of music, plays, poems, and journal articles, and then to distribute them to nearly hundreds of millions of users on the web at a cost that is zero, so at a free cost. So in short, the internet has demonstrated the potential for destroying traditional conceptions and implementations of intellectual property, in particular the law that was developed over the last 2 centuries. So the major ethical issues related to e-commerce and intellectual property concerns are how we, both as individuals and business professionals, should treat property that belongs to others. The types of intellectual property protection. So there are 3 main types of intellectual property protection. We have copyright, patent, and trademarks. Now these are all laws within the United States. Now Congress passed the first copyright law in 1790 to protect original written works for a period of 14 years. With 14-year renewal if the author was still alive. And I know this is going to be a typo. It's not 1790, it's going to be 1970. Since then, the idea of copyright has been extended to include music, films, translations, photographs, and most recently designs of vessels under 200 feet. The copyright law has been amended 11 times in the last 40 years. The goal of intellectual property law is to balance 2 competing interests, the public and the private. The public interest is served by the creation and distribution of inventions, works of art, music, literature, and other forms of intellectual expression. The private interest is served by rewarding people for creating these works through the creation of a time-limited monopoly, granting exclusive use to the creation, or to the creator, I'm sorry. So now we're going to get into the significant developments and the copyrights, the patents, and trademarks. We'll start with the copyrights, which is the problem of perfect copies and encryption. Now in the United States, copyright laws protect the original forms of expression, such as writings, art, drawings, photographs, music, motion pictures, performances, and computer programs from being copied by others for a certain period of time. Copyright does not protect ideas, just their expressions in a tangible medium such as paper, cassette tape, or handwritten notes. So it's good to know that it's just, copyright does not protect ideas, only stuff that's actually in a tangible medium. Now the fair use doctrine, copyrights, like all rights, are not absolute. There are situations where strict copyright observance could be harmful to the society, potentially inhibiting others' rights, such as the right to freedom of expression and thought. As a result, the doctrine of fair use has been created. Now, the doctrine of fair use is going to permit teachers and writers to use copyrighted materials without permission under certain circumstances. Now, Table 7.7 is going to describe the 5 factors that courts consider when assessing what constitutes fair use. So once again, this is on the bottom of page 280. So just some of the fair use factors. I'm not going to get into the interpretation of them, but the fair use factors listed in Table 7.7 is going to be character of use, nature of the work, amount of work used, market effect of use, context of use. So these are the fair use factors that courts are going to consider when assessing what constitutes fair use. So the fair use doctrine draws upon the First Amendment's protection of freedom of speech. Journalists, writers, and academics must be able to refer to and cite from copyrighted works in order to criticize or even discuss copyrighted work. So professors are allowed to clip an article before class or make copies and distribute it to their classroom. And it's important to know they're not permitted to do so from semester to semester without getting approval of the people who actually own this copyright material. And ultimately, the approval comes by ways of a fee in order to use this copyrighted material. So that's the fair use doctrine. Now, the Digital Millennium Copyright Act of 1998. Now, this is going to be the first major effort to adjust the copyright laws to the internet age. Now, Table 7.8 on the bottom of page 281 summarizes the major provisions of the DMCA, which is the Digital Millennium Copyright Act. I'm not going to get into this. If you want to read through this on your own, I'm not going to be pulling anything from the test. So if you're just curious and want to get into what the Copyright Act, the different sections, and what the importance of each of those sections are, feel free to do so. Once again, it's on the bottom of page 281. So the DMCA attempts to answer two vexing questions in the internet age. The first question: how can society protect copyrights that are online when any practical encryption scheme imaginable can be broken by hackers and the results distributed worldwide? The second question being: how can society control the behavior of thousands of ISPs who often host infringing websites or who provide internet service to individuals who are routine infringers? So very important questions there, which makes it difficult for the DMCA to address. So many companies such as YouTube and Google have latched on to the provision of the DMCA that relates to removing infringing material upon request of the copyright owner as a safe harbor that precludes them from being held responsible for copyright infringement. So what's this mean pretty much? It means that if there's a website out there that accidentally or knowingly, which a lot of cases I believe they do know, put material on their website that is protected by a copyright or a patent. So what that means is if the people who actually own this intellectual property come to them and say, hey, this is our copyrighted property, you all need to take this down, then they have the right to actually take that down before being prosecuted for impeding upon that copyrighted work. So it's pretty much giving them that little safe harbor of saying, oops, sorry, I didn't know, I'll take it down since you have a copyright to it. That's long and short what that's saying. So the entertainment industry is going to continue to be aggressive in pursuing online copyright infringement. In 2011, in a suit brought by the Motion Picture Association of America, a federal judge ordered DVD streaming service Zediva to shut down. So that's how much power they can have if they want to. They actually made this company shut its operations down completely. File sharing continues to be an ongoing copyright issue as well. So GrooveShark, a U.S. digital music service that lets subscribers stream several million songs for free, was being sued by the four major music firms for copyright of infringement. In 2012, both Google and Apple have removed GrooveShark apps from their stores. So obviously, as a result of this litigation, they have separated themselves from GrooveShark. That's all I have for today. We'll pick back up on Friday, on page 283 of Chapter 7. We'll pick up with patents, business methods, and processes. Remember that tonight, let's make sure I'm telling you right, Chapter 6 homework is going to be due in 15 hours and 19 minutes. So it's due tonight at 11:55. And it looks like it's already been submitted, so I will get that grade back to you all. I appreciate that, everyone getting the work in. And that is all I have for everyone. And once again, I will see everyone on Friday. Everyone have a nice day.